Good afternoon. This is Greg Lois, and I'm here today to talk to you about New York workers' compensation law. Our topic, settlements, releases, resignations, and the aggregate trust fund in New York. Today is November 4, 2024, the day before Election Day. Thanks for joining us. Let's dive in to our topic. And please remember, this presentation is intended for our webinar audience, and it is for instructional purposes only. I'm not providing advice as to any particular matter. If you do have questions about specific cases, please feel free to email or call me, and we'll talk about those questions that you may have. All right, let's begin with our first topic, which is Section 32 settlements in New York. And Section 32 is just a section of the statute which allows us to resolve any case that is pending before the New York Workers' Compensation Board with a full and final lump sum dismissal. So for a lot of reasons, this is one of my favorite sections of the workers' compensation law. Now, there are some specific rules that we have to follow in doing one of these agreements. The first rule that we have to follow is that the agreement has to be in writing, it has to be very specific, and we have to submit this proposed Section 32 agreement to the Workers' Compensation Board and have either a law judge or a bench approval of the Section 32. Now, interestingly, we don't have to have a proceeding before a judge. We can request that the Section 32 is settled and resolved on the papers. And in fact, that's what we do in every case. However, my opposing counsel do not like to do that because the board generally will award them less of an attorney's fee if there isn't a formal approval on the record. And so for that reason, even though we often request a bench approval, that is not requested by opposing counsel. So a Section 32 offer must explain clearly what the specific benefits that we are asking the claimant to waive in return for a specific monetary amount. And again, all of these must go before a law judge who must be approve it, whether again in person or through a bench approval process. Once the settlement is approved, there will then be a new order issued by the Workers' Compensation Court. Usually takes a day for that order to be issued and filed in the electronic docketing system. And then the parties have a 10-day cooling off period. And the idea here is that if one of the parties says, wait a second, I don't want to do that settlement or waive those rights, you have 10 days to abandon an approved Section 32. Now, this is New York, and you know my joke about New York. They love their forms. This is a very form-driven jurisdiction. And so in order for a Section 32 settlement to be put through and approved, a number of forms have to be received. Now, the first is the basic waiver agreement. It is just simply lays out the subject of the settlement with extreme specificity. And again, we use a template document here at LOIS Law Firm that we modify to fit the unique facts and biographical information of each case. But there are several provisions in our form that we never change and that we argue should always be part of the Section 32 agreement. So for example, waiver of Section 29 lien rights, or arguing that Section 29 applies to the proceeds of the Section 32 settlement. That's something that we include in every single one of our settlements, and we never want to take that out. So it has to be reduced to a writing, and then the board, of course, requires these forms, as I mentioned earlier. One of the forms is the Form C-32.1, where everyone affirms, swears that these are a voluntary acceptance of the settlement proceeds that have been offered. We're also, of course, going to provide a copy of the agreement between the parties. And in the last 2 years, we are now required, when we represent a carrier or self-insured employer, to file an attorney affirmation form or affidavit, which I'll discuss further, that says the contents of the Section 32 documents that we've submitted to the board either do or do not constitute the entire settlement and all the agreements between the parties. So again, I'll explain that a little bit further as we go along. Voluntariness of the acceptance of this has to be very specific. The board requires that the claimant fill out a form indicating they understand they are giving up their rights, and now they require the claimant to watch a video which is hosted on the Workers' Compensation Board's website, which further explains the rights that they are giving up by accepting the Section 32 settlement now. Now, it's important to note that the parties can include in the Section 32 document statements that say things like, upon signature or execution or acceptance of this Section 32 agreement, the claimant's right to medical treatment and maybe even temporary disability benefits is suspended. So you can do some self-help. If you've reached an amicable resolution of your workers' compensation case, I think it's always very wise to put into that Section 32 offer an agreement that once this offer is accepted, we are going to suspend your temporary disability benefits. One of the most practical reasons to do that, of course, is that we can't actually control how long it takes the Workers' Compensation Board to actually list that Section 32 settlement proceeding, agreement for a approval proceeding. And so it might take 30 days, 45, maybe even 60 days for you to get a hearing approving it, and you don't want to be paying temp during that entire period of time. So that's a very important thing to include in your Section 32. You can do other things with the Section 32 agreement. You can ask the claimant to withdraw a claim or just pieces of a claim. You can also resolve cases and issues in other jurisdictions. But I caution you, even though you have the power to do this, the other jurisdiction doesn't have to recognize the authority of the Workers' Compensation Court to resolve or waive rights in other jurisdictions. So in practice, we do not do that. Another interesting thing about Section 32 is that if we are doing a full and final waiver or release or settlement with opposing counsel, the claimant's case, and we have raised Section 114A, which is the fraud provision of the Workers' Compensation Law, we have to state in the Section 32 that the fraud allegation has been resolved and is withdrawn. That's important because that protects the claimant from future prosecution. Further, we should address all outstanding medical bills, if any. Now, I'm going to take a little bit of a detour now because I want to talk about something that is rarely used, but I just want to let you know about the option to do it. So what are other ways that we could resolve issues? And I want to talk specifically about employer or carrier penalties. I do have clients that say, Greg, I hate getting these penalties. And by the way, the board loves to issue them all the time. A common situation could be the carrier has not appeared at a hearing, and so they've been penalized a specific sum of money. You don't want to pay the penalty or have that go on your books as you were penalized. So there is an opportunity to use the M&T to perhaps resolve some of these issues. Now, there is a thing called an M&T, which is a medication and transportation cost reimbursement. There is a form for it, of course, because New York loves forms, Form C-257. Now, these payments are meant to reimburse the claimant, for example, for medication costs that weren't paid on a prescription card, or transportation to and from medical appointments, or perhaps even some durable medical goods, things like a cane or something like that. But you can also use these to creatively resolve issues such as penalties. And I do like to mention this just so that you know that there are some options or opportunities that you might have to try to resolve issues, particularly penalties that are payable to the claimant. From the claimant's point of view, they don't really care if they get a $1,000 penalty for failing to attend a hearing. The claimant doesn't care whether that's paid to them as an M&T or as a penalty. Either way, it's tax-free, so from their perspective, they don't care. And so that's maybe a potential thing for you to think about. All right, let's turn on to my next subtopic here, which is releases and resignations. And these are sometimes sought in conjunction with the Section 32 at the same time. Of course, these are going to travel along a separate path, but I do want to talk about the process, which is very common in this jurisdiction. And if you're wondering, I know some jurisdictions, a release or a resignation from the employment is rare. For example, I practice in New Jersey. I've been practicing in New Jersey for decades. And I can tell you, it's very, very rare. Maybe once a year do I get a release and resignation. But in New York, it's very routine. Release and resignations are getting done almost in every case that we defend, and everyone's doing it. So it isn't a deviation from normal practice in this jurisdiction. So if it's something that you want to do in your cases, it's absolutely appropriate and can be done in this jurisdiction with no problem. So what is a release? What am I talking about? And what is a resignation? Well, a resignation is simply a legal document where one party agrees to resign from their employment position. And a release is any general release. Usually it's releasing present or future rights. These are totally legal documents. However, they might not be enforceable, and they're certainly not enforceable before the Workers' Compensation Board. And the reason I say that is because the Workers' Compensation Board has no jurisdiction over any other past, present, or future claims against the employer, of course, other than workers' compensation claims. So some practical applications I just want to talk about. What do we do when we're closing cases and we're doing them by way of Section 32, and why we talk about resignations or terminations at that time? Well, it's for practical reasons. Section 32 is not technically a payment of compensation, and it is not re judicata. You do not get, for example, to argue in a future claim against you by the same employee, hey, you say you hurt your back now, but we just did a Section 32 with you 3 weeks ago for $15,000 because you said you hurt your back then. Unfortunately, that prior payment of a Section 32 is not re judicata. It does not foreclose or forbid or bar the claimant from coming right back into your employment, and the very next day after they come back to the employment, making an allegation of injury to the exact same body part. So how do you protect yourself from this? So one of the answers has been to ask for the resignation of the employee. Now, oftentimes this is purely academic because years have maybe gone on from the time of the loss, and maybe this person doesn't work for you anymore. And so maybe this is entirely academic, but sometimes it's not. And we want to be considerate of the right of the employer to say, hey, well, I want to make this offer and see if they want to resign, right? So that's absolutely fine. So let's talk about first about terminations, separations, layoffs, and how that impacts how we handle employees where we are already defending or handling a workers' compensation case. In fact, it's one of the most common questions I get. The employer will call me up and say, hey, Greg, look, this person's out on workers' comp. I need to know, am I allowed to fire them or do I have to keep their job open forever? And I am very careful about the advice I give them because I tell them you are always able to terminate someone if you have a valid and legitimate business reason to do so, but you can't terminate someone simply because they filed a workers' compensation case. That is discriminatory. It is foreclosed and forbidden by the Act. In fact, Section 120 of the Workers' Compensation Act says it shall be unlawful to discharge or fail to reinstate an employee because they have claimed or attempted to claim compensation, requested a claim form for injuries, claimed any benefits provided under the workers' compensation law, has testified or is about to testify in a workers' compensation proceeding. So that's very broad, and it says, hey, you can't discriminate anybody, even if they're going to be an adverse witness to you, if you think that they're bringing in claims, you can't do that. Okay, now, my warning to employers is, if you do violate Section 120 and act in a discriminatory manner, we're going to talk about that in a second, the penalty is not against the insurance carrier. If you're insured, the penalty is directly against you. So self-insured, this comes right out of your pocket. And if you are insured, if you do have an insurance carrier, they are not going to pay these penalties, and they are not going to pay the cost of restituting the employee, because the law allows for penalties and it allows for the claimant to be reinstated in their prior employment. So be very mindful about this. Now, if there's a legitimate business reason, you can separate someone. So you can always fire someone for a legitimate business reason. What does that mean? It means you might have a lack of work or general economic conditions. Hey, we're shutting down the plants, Greg. We're doing less shifts. We don't need as many people. We've automated. we're not selling as much. There's a slowdown. Okay, you don't have to keep the person's job open forever, particularly where there's a lack of work or you have a general business reason to do it. Another legitimate business concern is that the employee can't perform the essential function that needs to be done. What does this mean? It means, hey, if you are a small shop and you only have 3 or 4 employees and one person's out on workers' compensation and you don't know when they're coming back, it's acceptable to terminate them and hire another worker because you need to get the job done, okay? Any essential function. Now, another thing is if they can't perform their duties, even with assistance, even with accommodation, if they can't do the duty, you have no obligation to keep them employed. All right, now I'm going to talk about the last application of this, or second to last application, which comes up so often, right? The claimant makes a workers' compensation claim against you. You deny the claim because you do not believe there was any work-related accident, for example, or any other valid legal defense. They then file a Section 120 complaint against you saying you've discriminated against them by denying their case. Well, there is case law that says simply denying a workers' compensation case is absolutely not a valid basis for them to claim that you've discriminated against them. We have the right to vigorously oppose workers' compensation and unemployment insurance claims anytime we want. Okay, that cannot be limited by Section 120. Another thing that we should be mindful of is misconduct terminations. If someone is, if during an investigation, maybe after an accident, you discover they committed misconduct, you can terminate them. That doesn't mean, just because they're collecting workers' compensation benefits, it does not mean that they are shielded or protected from discharge due to their own misconduct. And there's a great example in the Fetahash versus Starbucks case about the claimant who is providing false information to the employer in their workers' compensation incident report. And they were terminated for filing the false information and making false claims and trying to get coworkers to ask them to write false reports that he was injured at work. The employer terminated him. The employee turns around and files a discrimination case, and the employee lost. Now, the evidence of this discrimination, the law simply says it needs to be sufficient. Sufficient. Now, in cases that I'm citing here, and the Markey versus Autosaver Ford case from 2020, the board found it sufficient that the employer told them, quote, after he was told that he was going to be injured at work and he needed time off to recover from his injuries, the employer said, quote, "I'm not going to be happy with that," close quote. Immediately fired him after that. I mean, that even though they didn't say, "I'm firing you because you filed a workers' compensation claim," they let him know they weren't happy about the claim and then immediately terminated him. Other employers who try to get cute, the Gazowski versus Pacos case from 1990, in which the claimant, the day they were released to return to work from workers' compensation, they fired him. Statements to the claimant, typically saying, "I'm going to fire you if you file workers' compensation," or saying to an employee, "We fire everyone who files workers' compensation cases," like the Hawes versus Dime Savings Bank case, which I'm citing now from 1989. All of those will be found to be per se discriminatory. So some takeaways on separation. My takeaways to you as the employer is if you have a legitimate business reason, you can terminate someone while they're collecting workers' compensation. You do not have an obligation to keep their job open forever. However, I caution you to be very careful about it and not do it for discriminatory or retaliatory purposes. The court is going to look at the timing, the statements you're making, and they're going to determine whether or not this was a legitimate separation. So again, be careful, call your counsel. Resignations, right? The way to get around separation is resignation. And again, this typically happens in the context where the claimant has not worked for us for a long period of time, sometimes years. It's an academic discussion at this point, but we need to address it. Now, under the law, we are not allowed to demand that the claimant resign their position as a condition of any type of settlement, whether that be by Section 32 or stipulation. However, you are legally allowed to still seek a resignation separately and apart from the workers' compensation settlement. The law says nothing about what we're supposed to do or who we're supposed to report to that we have obtained a resignation. However, the Workers' Compensation Court has made demands that we let them know if we have sought a resignation or done any sort of side agreement with the claimant that affects their employment. We don't have to disclose the terms of the resignation agreement. And again, the board lacks jurisdiction over resignation agreements in any way, certainly can't enforce them, and they certainly can't cancel them. But they do want to know if that is happening, and they are requiring it as a part of any Section 32 settlement. Resignations generally require the claimant to state they are no longer working for us, they understand that they have withdrawn from our employment, and they will not seek rehire or reapplication for the same position. However, I'll tell you that in the last year or so, the Workers' Compensation Board is not approving Section 32 settlements where the claimant is required to not apply for the same job. Now, it's interesting that even where there is money provided as consideration for these resignations, sometimes a lot of money, the board doesn't like the language where the claimant says, I will not reapply for the same job. I honestly cannot understand the board's position in this regard. The person generally is, or the claimant is generally not working for the employer anyway at the time these resignation agreements are reached. The idea that they won't reapply doesn't seem that onerous to me or burdensome. I would also tell you that in the general employment context, severance agreements that say you'll never work here again are very, very common. But this has recently become a very big sticking point. And I would say over the last year, we're seeing more and more judges, and this is very much judge by judge, are disputing whether or not they will accept those, even again where a large sum of money is moving. Now, resignations can be obtained in return for consideration, for money. Now, some of our clients will pay no money for a resignation. Some will pay a little bit, like $100 or $1,000, and some will pay a lot, like a multiple of a few weeks or even a month's pay for a resignation. But again, anytime some of this specific language is used, be careful because the board's judges might not approve it. I also want to point out that resignations should not be sought out or paid for by an insurance carrier because this exceeds the insurance contract. It's really only direct employers that should be engaging in the seeking of resignations, or our next topic, which is releases. Okay, that makes sense, right? There is no insurance contract, workers' compensation insurance contract anyway, that says that the carrier is responsible for obtaining resignations from the actual employment. In fact, it should be silent on that because that's not something that should be addressed under the workers' compensation law. And certainly getting general releases or releases of future or prospective claims should not be covered by workers' compensation insurance because workers' compensation insurance just simply doesn't cover those risks, right? So those are all things that shouldn't be covered. So let's talk a little bit about releases in general and then apply them in workers' compensation. So you can make a demand as part of your Section 32 settlement that the claimant execute some type of general release or release claims or rights outside of the workers' compensation context. It doesn't per se nullify the Section 32 agreement. And there are some instances where the claim in the other jurisdiction might arise from the same facts and circumstances, like, for example, wage and hour dispute, and the resolution of the matter under the workers' compensation law might resolve the matter in the other jurisdiction as well. But just remember, even though you can ask the claimant to waive or release rights in other jurisdictions, I think that's a little bit fraught because remember, the Workers' Compensation Court is not really a court. It's an administrative agency. It's not a constitutional court seriously at all. And it doesn't have, it's a limited authority court place, so it does not have the opportunity to really mediate or resolve disputes in other jurisdictions. So just be thoughtful about that as you negotiate these. Specific releases are often provided to us by employers. Usually general counsel says, hey, Greg, here's the release we'd like. Again, it'll generally release all sorts of unrelated potential future claims, like wage and hour claims, law against discrimination claims, civil rights claims, etc. Now, remember that some of this is all null because some specific claims cannot be resolved prospectively. However, I do understand that there is like a psychological effect to these releases. We're telling the claimant, hey, your journey with us has come to an end. We're not going to litigate with you ever again in the future. Here's your Section 32 settlement. We're asking for a release in return of all of these other prospective rights. I think it brings psychological closure to a case. And for that reason, I do think it is useful. How much do we pay for these types of releases? There may or may not be consideration offered at all. And just like a resignation, sometimes some of our clients will offer no money for release. Some will offer a nominal sum, again, like $100 or $1,000. And some will be quite generous, offering multiple weeks or months of pay in order to obtain these releases. Same thing as resignations. Releases cannot be sought by or paid for by an insurance carrier because, again, this exceeds the insurance contract. Only direct employers should be seeking and obtaining releases. All right, let's talk about hold harmlesses. I know this sounds like, hey, Greg, you're just talking about waivers with a different word. But really what I'm talking about when I talk about hold harmless is including language in your Section 32 in which the claimant, we try to shift risk to the claimant and we try to ask them to indemnify us against usually their own bad behavior. Now, in general, the board, the judges will not approve a Section 32 waiver where the claimant is required to indemnify or hold us harmless. And I'll give you an example. I mean, the most common example is we would put language into our Section 32s that would say something like, the claimant will indemnify and hold the carrier harmless for any payments made by Medicare for treatment of the claimant's work-related injuries prior to the execution of the Section 32 waiver agreement. You know, something like that. What are we trying to do? We're trying to protect ourselves from this silly-hearted claimant going out and running up a whole bunch of conditional payments that we're then going to have to resolve, right? So there is a valid and a good reason to put that in there, but the board does not like anything where the agreement shifts risk to the claimant. The second example of that is where we'll put sentences into our settlement agreement. They'll say things like this: claimant will indemnify and hold harmless the insurer in the event that the insurer incurs liability as a result of the claimant's failure to safeguard the fund of a self-administered Medicare set-aside account established pursuant to the agreement. So many cases have set-asides. That's a separate topic that we could talk about. I believe that topic has been talked to death. But many Section 32s require a Medicare as secondary payer set-aside arrangement where the claimant is given a second source of funds to pay for future medical care. And they're supposed to use that source of funds only for medical treatment. Do they do that? Not always. Do they ever invade that fund and take it and go on a lavish vacation or do whatever? Yeah, the answer to that is absolutely yes. And in that context, you know, we want to make sure that we're protected if they essentially embezzle from themselves, right? They go into their set-aside arrangement and they take those funds and they use it for purposes that it's not supposed to be used for, which would be anything non-medical. We're trying to protect ourselves from having to even get involved or defend that case. We would expect Medicare to go directly after the claimant and say, we are now suspending your benefits until that amount of money is restituted. But again, all of these attempts to put hold harmless agreements or indemnifications into our own cases, into our own Section 32s, are generally going to be rejected and denied by the board. So don't do it. All right, some best practices. Section 32s, full and final dismissals, which is, again, what we love. We want to be really clear and be very, very specific about what we are obtaining and what we are asking for, we are asking the claimant to waive and what we're willing to pay. Again, if there are separate agreements, this needs to be revealed to the Workers' Compensation Board. And I'll tell you that some statements, things like statements that if the claimant does not resign from the employer within 10 days, the self-insured will withdraw from the agreement. Those types of things are going to be challenged or might be problematic with obtaining a full and final resolution approval. Remember that we have to submit that affidavit form, the C-32AF, which indicates to the board any separate agreements that have been reached between the parties. Now this is an affidavit, so when I sign it, I am signing that under penalty of perjury, so believe me, we take those very seriously here. We have to reveal the presence of those other agreements. Upon completion of it, you're done. You don't have to reveal the result, the subject, or all of the language that's in the other agreements, whether that's a resignation or a release, or both, release and resignation. The board might require or request at a hearing, they'll say, hey, we want to see that release and resignation. We want to see what the language says in there. And I'll generally refuse to do that, saying, well, this board has no jurisdiction to review that. However, I can't stop the claimant from submitting an executed release and resignation. So although I do try to protect the agreement and keep it out of the review of the court, I can't stop the opposing party from submitting it if that is what they want to do. So just be mindful about that. Some best practices from in our office, where an insured client wants to do a release and resignation. Remember, there's a workers' compensation carrier in the insured context. That carrier should not be paying for or in any way involved with obtaining a release and resignation, because again, it exceeds the insurance contract. At LOIS Law Firm, what we will do is open a new matter, a separate matter, completely separate from the workers' compensation matter. We will do a separate engagement with the employer directly. We will do a special waiver with them. In other words, we're going to tell them, you understand that this is a limited engagement. We're only being engaged for the purpose of obtaining this release or resignation. And then again, if I reach that release and resignation, I will have to state the same. So that is how we handle them here. All right, last little topic that I'm going to talk about today is the aggregate trust fund, because this does impact some of our resolutions or settlements before the Workers' Compensation Board. And certainly anytime you're ordered by the Workers' Compensation Court to make a payment, you should be wary of the fact that you, if you are an insurance carrier, may have to make a deposit into the aggregate trust fund. And this is a required deposit of future exposure with the state. Exempted are all self-insureds and the state insurance fund. The one limitation is that the judge should not order contribution to the aggregate trust fund where there is a third-party case pending. And the reason for that is obviously your exposure might be dramatically reduced if the claimant obtains a recovery in a third-party case. The aggregate trust fund, after the future exposure is deposited with the state, has the opportunity to directly negotiate with the claimant a Section 32. And oftentimes, this will really make our negotiation of a Section 32 difficult, because everyone knows that the aggregate trust fund is going to be a little bit more generous than we are, because it's not their money. They're really playing the game with somebody else's money. So for those reasons, this does make the negotiation of cases where there is a future exposure and the carrier has been instructed to make that deposit with the aggregate trust fund a little more difficult. Now, I will tell you that it takes several months for the aggregate trust fund to calculate and provide you a demand for contribution to the fund. You do get some present value discounting, so you don't have to pay the face value, at least, to the fund. And when that happens, when you get direction to make a contribution to the aggregate trust fund, that's the opportunity to be turning around to opposing counsel and attempting to resolve your case. All right, some takeaways from today's presentation. I want to remind everyone that a release and resignation is possible. Often that will require additional consideration, a little more time when we're developing our final settlement documents. And lastly, beware of direction to pay awards to the aggregate trust fund. All right, thanks for joining today. If you enjoyed this, please go on our website, sign up for our newsletter. It's loisllc.com/newsletter. We send out newsletters about once a week, usually full of trial wins and results that we're obtaining. And if you really like workers' compensation and ready for some next level discussions, I'd just point you towards my partner Christian's podcast. It's called Third Fridays. He releases it once a month, and it's really great. And we have a whole bunch of podcasts on New York, New Jersey, workers' compensation topics that you can check out and consider obtaining. Go to loisllc.com/podcast or anywhere that podcasts can be downloaded. It was great spending time with you today. Thanks for joining me. Get out there and vote, and I hope your candidate wins. Have a great day, everybody.